We're back again with a new motion in Lemine. State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. Motion in Lemine. Now comes the State of Indiana by prosecuting attorney Nicholas C. McClellan and respectfully requests that the court enter an order requiring the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument, any and all references to the following, either directly or indirectly. 1. Any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney. Johnson v. State, 453 NE 2D 365, Indiana Court Appellate, 1983. Craig v. State, 267 Indiana 359 370 NE 2D 880, 1977. And Bardener v. State, 587 NE 2D 1353, Indiana Court Appellate, 1992. Flynn v. State, 379 NE 2D 548, Indiana Court Appellate, 1978. Number 2, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty, Indiana R. Prof. Conduct 3.4e, Hossman v. State, 473 NE 2D 1059, Indiana Court Appellate, 1985, U.S. v. Young, 470 U.S. 1038, 1985. For instance, defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. 3. Any innuendo or inference that is not supported by admissible evidence. Indiana R. Prof. Conduct 3.4e U.S. v. Elizondo, 920 F. 2D 1308 1313, 7th Circuit, 1990. Also U.S. v. Wolf, 787 F. 2D 1094 1098, 7th Circuit, 1986. Benson v. State, 762 NE 2D 748, Indiana, 2002. Attorney cannot assert unsubstantiated allegations on collateral matters. Bagnall v. State, 413 NE 2D 1072 1076 77 N4, Indiana Court Appellate, 1980. Attorney may not comment or allude to admissible evidence during trial. Connolly v. DeCristoforo, 416 U.S. 637, 1974. 4. Any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issue in the case. Von Allman v. State, 485 NE 2D 55, Indiana, 1986. 5. Any attempt during voir dire to have the jury prejudge the credibility of a witness. Hahn v. State, 565 NE 2D 362, Indiana Court Appellate, 1991. 6. Any hypothetical questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. 7. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issue, or has the potential to mislead the jury in violation of Rule 401. Lashbrook v. State, 762 NE 2D 756, Indiana, 2002. Pelley v. State, 901 NE 2D 495, 2009. Before any such evidence may be permitted, the defense must show some correlation between the third party and the crime. Holmes v. South Carolina, 547 U.S. 319, 2006. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. McIntyre v. State, 717 NE 2D 114, 1999. McGaha v. State, 926 NE 2D 1050, Indiana Court Appellate, 2010. Tibbs versus State, 59 NE 3D 105, Indiana Court Appellate 216. The state requests such order in limina to include but not be limited to the following. A. Odinism. B. Cult or ritualistic killing. C. Brad Holder. D. Patrick Westfall. E. Johnny Messer. F. Elvis Fields. G. Ned Smith. H. Rod Abrams. I. Kagan Klein. J. Jerry Klein. K. Ron Logan. 8. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401, IRE 401. Burden is on the opponent to show why it is relevant. Mullins versus State, 646 NE 2D 40, Indiana 1990. Relevant evidence may be excluded if it is probative value is substantially outweighed by its prejudiced effect. Ralston versus State, 81 NE 3D 1097, Indiana Court Appellate 2017. Evidence may be excluded if it confuses the issue. Lee versus Hamilton, 841 NE 2D 223, Indiana Court Appellate 2006. 9. Any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401, IRE 401. Burden is on the opponent to show why it is relevant. Mullins versus State, 646 NE 2D 40, Indiana 1995. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudice effect. Ralston versus State, 81 NE 3D 1097, Indiana Court Appellate 2017. Evidence may be excluded if it confuses the issue. Lee versus Hamilton, 841 NE 2D 223, Indiana Court Appellate 2006. Number 10. Any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for. That is not an act that is an exception to IR 404B, and that it is not both relevant under IRE 401 and tend to negate the guilt of the defendant. Garland versus State, 788 NE 2D 425, 2003. Allen versus State, 813 NE 2D 349, Indiana Court Appellate 2004, IRE 404. 11. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of 401, IRE 401. Burden is on the opponent to show why it is relevant. Mullins versus State, 646 NE 2D 40, Indiana 1995. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudice effect. Ralston versus State, 81 NE 3D 1097, Indiana Court Appellate 2017. Evidence may be excluded if it confuses the issues. Lee versus Hamilton, 841 NE 2D 223, Indiana Court Appellate 206. 12. Any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as a part of the 6-year investigation into the murder of Abigail Williams and Liberty German that are not relevant or would tend to cause confusion of the issues or has the potential to mislead jury in violation of 401 rule, IRE 401. Burden is on the opponent to show why it is relevant. Mullins versus State, 646 NE 2D 40, Indiana 1995. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudice effect. Ralston versus State, 81NE3D 1097, Indiana Court Appellate, 2017. Evidence may be excluded if it confuses the issues. Lee versus Hamilton, 841NE2D 223, Indiana Court Appellate, 206. Wherefore, the State of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief. A. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside of the presence of the hearing of the jury. B. To further order said persons to make no reference to the facts that this motion has been filed and granted, and all other relief just and proper in the premises. Nicholas C. McClellan, Attorney, 28300-08, Prosecuting Attorney. Thanks for watching. There's going to be more to come in the Richard Allen case, so stay tuned to Deb's True Crime Notebook. And while you're at it, hit the thumbs up, the bell for all notifications. Please leave us a comment and share this video with a friend. See you next time.